All right, good afternoon, everyone who's joined us for today's webinar hosted by SVA. My name is Krista Gruen. I'm a partner at SVA, and today I'm going to be presenting on a webinar with one of SVA's associates, Ariana Schrowen. When we're not working from home, we are both working out of SVA's Toronto office. So this is one of a series of many SVA webinars that we put on. For Ariana and I in particular, if you can't tell, we're the two of the firm's most Dutch lawyers, which makes our last names all the more difficult for people to pronounce. So sorry for that. Just a little bit about our firm. For those of you who may not know, we practice exclusively in insurance defense. We are currently sitting at about 20 lawyers. We have 3 offices in Toronto, of course, as I mentioned, Kitchener-Waterloo, and London. We are led by a female majority partnership, and we proudly support and actually volunteer for an organization in Toronto and Kitchener-Waterloo called Shelter Movers. If you ever want to get involved with that, please let us know. We'd be happy to have that. Our webinars are 30 minutes long and they are recorded. So if you want to check out any of our past webinars, please don't hesitate to go to our website. And they run every 3 weeks or so. So if you're not already on our subscriber list, please reach out to any one of us and we'd be happy to get you on. And same if you have any colleagues who might be interested, please let them know as well. And they'll be on our mailing list as well. So before we get started into today's webinar, just a couple of housekeeping points. If you can't tell already, we've muted all of your lines and video. So you can see us, we can't see you. So don't worry about that. There will be an opportunity for some questions at the end. So you'll see a Q&A button for any questions you have, just throw them in there and we can address them. If we don't have time, we can certainly reach out to you after the presentation. We do also, as you can see, have a PowerPoint presentation. If you would like a copy of that, just reach out so you don't have to scramble down all the case law references that you see. We'd be happy to share that with you as well. So without further ado, I'm going to introduce our webinar topic for today. This topic is focused on FLA damages, specifically on fatality cases. And the reason this topic came about, if you haven't already heard, and you probably have if you're here, was a relatively recent Court of Appeal decision, Moore and 7595611 Canada Corp. We think everyone who works in bodily injury really needs to be mindful of this case. It raised some serious eyebrows by upholding a pretty significant FLA damages award when considering claims for loss of care, guidance, and companionship. To most of us, it came as quite a surprise when considering the case law leading up to it and what we thought was some predictability when it comes to FLA damages. The Moore case awarded additional damages, including damages for mental distress and other aspects, which you'll see, which all of those could easily be a webinar topic of their own. So for today's purposes, we're really going to be focusing on the loss of care, guidance, and companionship. And the court's confirmation from Moore that there is now no cap on that head of damages, which we think is one of the most salient outcomes of that case. So without further ado, I'm going to turn it to the roadmap so you can see where we're going today. So first, Ariana is going to give us some background about the source for these types of FLA damages and briefly guide us through a handful of the key decisions, there's about 7 or 8, relevant to these types of damages leading up to the Moore case. And we think they're important to be aware of as part of the landscape for talking about the Moore decision. And once Ariana does that, I'm going to take us through the facts of the Moore case, the basis of the Ontario Court of Appeals decision, and try to offer some insight as to what it means and where we go from here. So I'm going to stop there and turn it over to Ariana to launch right into it.
Thank you, Krista. I'm going to jump right into it with the history, as Krista indicated. Where do we find the basis of FLA claims? The answer is Section 61(1) of the FLA Act. At the most basic level, if someone is killed by the negligence or fault of another, and they fit into that cast of family members outlined, such as a parent, sibling, or child, the living relatives may have a claim for damages. But now let's consider what's encompassed in FLA damages. For our purposes today, as Krista said, we'll be looking at the loss of care, guidance, and companionship of the deceased. I'll probably be referring to this as the loss of care, so I'm not repeating a mouthful every time. These are big concepts, and their application of the courts has not been entirely consistent, as we'll come to see in the following cases. However, there are some early considerations before we go headlong into the cases. First, you do not need to have a family member actually pass away in order to receive damages for loss of care. However, fatality cases attract these larger awards that we'll see and are typically the ones we see most decided. As well, the Moore case deals with fatality, so that'll be our central focus. But importantly, FLA claims are not subject to the statutory deductible of the Insurance Act, which should always be kept in mind when we're calculating any potential exposures if we have a bodily injury case. Now, what are the factors the court considers when assessing FLA damages? As with the general principle of assessing damages, there is no clear-cut formula. The case of Augustus and Gossett listed the following factors on the slide as guiding principles when trying to quantify damages. Now, these factors, such as the circumstances of the death, the relationships between the relatives, and the effects the death will have on the living parent or child, are particularly important and salient, as they will come to see, especially in Moore. I'll move now to some of the case law and the early benchmark. The first case we'll look at pre-Moore is the case of Toe and the Board of Education. This case is a seminal benchmark, especially for insurers when considering the quantum for the death of a child. The sad facts saw a grade 9 student who was killed playing handball when the net toppled over and crushed him during gym class. His parents then brought a claim for damages. And the court found that $100,000 adjusted for inflation was an acceptable high-end range for the parents to receive in damages, as he was both the firstborn son and started to help his father in the family business. Until the Moore case, Toe had been the benchmark for $100,000 being the high end and the meter stick of all comparison for cases in between. This is where we get the damages cap, so to speak. We'll move now to the case of Mason and Peters, which has a unique familiar situation, which is very important. The victim was only 11 at the time of his death when he was struck by a car. His mother had been abandoned by his father, and the mother was also a paraplegic as the result of her own car accident she had previously. So those all together were a big factor in deciding of damages for quantum. She relied on the son heavily, so the relationship was more than just purely mother and son. The mother received approximately $110,000 adjusted for inflation in 2021, and the sister received approximately $13,000. Importantly, for our purposes, the court upheld these amounts as being reasonable for their particular circumstances. We'll contrast this with the case of Rintoul and Linda State. The 16-year-old died in a traffic accident. He was the only son, and the family relied on him for guidance. The father had died years before, so he really was the only male figure in the home. In 2021 dollars, the mother was awarded about $83,000, and the sister received approximately $30,000. It isn't as much as the Mason case that we just covered, but we can already see the trend covering close to $100,000 in terms of damages. We'll next move to the case of Hamilton and Canadian National Railway. 9-year-old Suzanne Hamilton was struck and killed by a westbound GO train at the level crossing in Mississauga. She had siblings, but notably, when the case was tried at first instance, the family did not submit any medical evidence. $150,000 was awarded to the mother, but then reduced to $50,000 on appeal. Now, when adjusted for inflation, that does rise to about $82,000, and the siblings did receive about $12,000 to $16,000 each. Again, we're circling this cap, but we're not, as of right now in the case law, close to $100,000, but we're in the range. We now have the case of Osmond and the Numbered Company, which sees a swing to the higher quantums as compared to the last few. The 16-year-old victim was one of 10 kids and the bright spot in the family. He was actually stabbed and killed in a nightclub as compared to the other cases, which seemed to involve vehicles. And his family brought an FLA claim forward. The evidence showed that despite being one of 10, he was special, had a future, and unlimited potential, which was warranted. His parents received approximately $101,000 adjusted for inflation, while each of the 9 remaining siblings received $25,000. In this case, notably, $100,000 was awarded in punitive damages based on the particular grisly circumstances of his death. Now we're almost getting to the Moore case, and this will be the second last case that I cover. The case of Fiddler is particularly important in the pre-Moore case law, similar to that of Toe. A 17-year-old girl died in a transport truck that she was riding in struck another transport truck. She was not wearing her seatbelt, and the nature of her death was particularly gruesome, and that almost the entirety of her body was largely dismembered. Of importance, the jury initially awarded $200,000 to her mother, $50,000 to her father, and then $25,000 to her sister. However, the amount of damages awarded to her mother was then appealed to the Court of Appeal. So I've put up a poll for those of you watching live to select the potential outcome of this case of the Court of Appeal. For those watching live, how much did the Court of Appeal ultimately award the mother in Fiddler in 2021 dollars? Now that is key, 2021 dollars. The options are greater than 200,000, 150,000, $100,000, or $50,000. So if you could choose one of those answers, we'll take a look to see what everyone thinks the trend might be heading. So the majority seems to be $150,000. And surprisingly, all of you are on the money. The mother's damages were reduced to $125,000, which, when adjusted for inflation, was $150,000 in 2021. Importantly for our purposes, the court felt there was no evidence to take this case out of the general range of damages we've seen in similar cases. That takes us right back to Toe, that suggests $100,000 was an upper cap on FLA claims. Now moving on to my final case, and that is Rodriguez and Putrell. This saw a 5-month-old die in a car accident involving a third-party impaired driver. The baby was the last planned child and the last opportunity to raise and love someone through their lifetime. The baby's mother was found to have a really tight relationship with the child, despite him only being 5 months old. The importance of the sibling relationship, however, was highlighted by the court and found not to be an insignificant role to consider when quantifying damages for siblings. As a result, the parents were awarded approximately $130,000, and each sibling was given $35,000. All of which is to say, we're now to today. As we've seen, the range of damages awarded seems to kind of sit between $85,000 to $130,000, but up to $150,000 with inflation, as we saw in Fiddler. However, as Krista will talk about, the Moore decision may or may not provide some clarity in future cases when deciding FLA quantums. I'll hand it over to Krista for her to go. Thank you for listening to the history.
Thank you very much, Ariana. History is really important when we're looking toward the future, as we know. So that's what makes the Moore case, I think, all the more surprising to some degree. So I'm just going to briefly go through some of the facts to help give a background understanding as to the recent ultimate outcome at the Court of Appeal. Like many of these cases involving FLA damages, this is a really heartbreaking case. It involves a 24-year-old woman named Alicia Moore. She died following a fire that broke out while she was sleeping in a basement apartment that she was living in at the time. Alicia had been renting out the apartment from her landlord, which is that numbered company 759-5611 Canada Corp. That landlord owned the building where she was living. So what happened was, while she was sleeping, the fire breaks out and Alicia became trapped as a result of the blaze. The windows in her unit were barred, and the only exit that she would otherwise have access to was engulfed in flames. So without an available exit, she was forced to wait upon emergency services to be rescued. Emergency personnel did ultimately rescue her, but she suffered third-degree burns over more than 50% of her body and was ultimately placed on life support in hospital. She was an only child to her parents, who stayed with her at her bedside throughout. Her parents saw her burns, they watched her physical state decline, and they were present for a whole bunch of cardiac events that occurred. And ultimately, her parents made the very difficult decision to remove her from life support, and she ultimately passed away after a few days. So what happens is her parents sued the landlord. and the case was tried before a judge and jury in late 2019. Ultimately, the landlord was found liable for failing to have and implement an appropriate safety plan for the building, failure to maintain operational smoke alarms, and failure to provide sufficient exits for the premises. So it's the damages award that we're really focusing on. So in Ariana's fashion just now, I also have a poll for us. And just bearing in mind the history of the cases and the facts that you just heard, what quantum of damages did the jury in Moore award to each parent for the loss of care, guidance, and companionship of their adult daughter? So select one of these options: 150,000, 200,000, 250,000, or 320,000. Skip here in a minute. Oh, we've got our results coming up now. Wow, you guys are good. So 60% guessed correctly at 250,000. So you're, as Ariana said, right on the money, not to use that pun over and over. But that was obviously awarded to, like I said, to each parent for the loss of care, guidance, and companionship of Alicia. So you can see the damages awards here. In addition to the loss of care, guidance, and companionship, you'll see that 250,000 was also awarded to each parent for mental distress. And then there was significant future care costs for both mom and dad, bringing the total damages figure to 1.3 million. So not an insignificant award rather, but also maybe not particularly surprising based on the facts, depending on who you ask. Many are falling into the camp of 250,000 for loss of care, guidance, and companionship wasn't enough. And others say, well, if you look to, as the defendant landlord argued, you look to some of the previous cases that Ariana just took us through, like Fiddler and Toe, and the high end would have been around just under 150 if we look at today's dollars. And that's what the defendant essentially argued on appeal. Specifically, the defendant relied on the premise that $150,000 was the high end of damages awarded in these kinds of cases and forms a benchmark of sorts when talking about damages and FLA claims. And just again, keep in mind that when we're looking at these other very tragic cases like Fiddler and Toe, we still get to less than 150,000. So it's a pretty big return. So the next slide, this is surprise. The Court of Appeal refused to change the damage award that the jury came to. They didn't want to interfere. And this is really the opposite of what we saw in Fiddler. And essentially the Ontario Court of Appeal said there's a very high standard for appellate intervention of jury awards. They have to shock the conscience of the court before the court will touch it. And in this case, they went back on that and essentially came to that conclusion that they said the jury got it right, and they refused to interfere with that. So when we think back to the previous decisions, perhaps somewhat unexpectedly, the court found that Toe did not set a cap on FLA damages. That's really what everybody looking at these cases, at least from the defense perspective, would say, that we've got a cap here. Gives some predictability. I mean, we have a cap for general damages, so it would make sense to have a similar cap for FLA damages. What the Court of Appeal did say was that 150,000, at least in Fiddler and Toe days, may be on the high range of FLA damages, but they looked at what the jury's conclusions were here and said, there's no legislative cap and there's also no judicial mean cap either. They made the point as well that there's no neat mathematical formula to come up with these kinds of damage awards because it's an immeasurable type of loss. And I think that's where you get the difference with the presumed cap on general damages versus FLA damages. And they looked at the facts of this case and more and said the damages awarded by the jury were not so inordinately high so as to be wholly erroneous in nature. And that's really where they based their decision. So when we look at, what does this mean and the thresholds, when will the court intervene? And as I previously mentioned, it's only going to be in situations where it shocks the conscience of the court. So based on this new decision and more, there's a few outcomes that we see potentially coming to fruition. But the basics are, and as you can probably tell by the decisions that Ariana just went through, claims involving FLA damages are highly fact specific. We always knew that, but this just highlights that further. And what might be key in future claims seeking these types of damages in, let's say, the $250,000 range or higher, is the fact that the award here was really supported by the parents in their testimony. There were people that witnessed the incident, and you have the aftermath where this wasn't a sudden death, it was pretty excruciating. And in addition, there was expert evidence that the court saw was very clear to corroborate the kinds of claims and testimony that the witnesses and particularly the parents were making. So when we say, what does this mean and where are we going? We have to consider the possible range of outcomes that we know. We see this case as having a $250,000 damage award, but that doesn't necessarily mean it's a cap either. So that obviously might make the hair on the back of your neck stand up a little bit if you've got a fact scenario that looks particularly gruesome or concerning in terms of fatality cases. So as I said, the kinds of paths that we have to think about are thinking about these very specific fact scenarios, the possibility that does exist that if something is so offensive as to drive a jury to make a similar award of that range or even higher, so long as the court looks at it and says, yeah, that's justified to me, then it's going to pass. And further, we just have to consider the court's signal to us that they're not going to be interfering with these types of jury awards unless it's completely outside the realm of possibility. So what to consider in your claims? Obviously, you're looking at the facts and maybe it crosses your desk really early on. But really what you're looking for, are there any particularly tragic elements that could elicit additional sympathy? Are we talking about a situation where we're dealing with an only child like we did in Moore? Or is this a situation where the parents have 11 children and this is one of while tragic, they have other children, or the prospect of having more children? That comes up a lot in the cases. And of course, are there experts confirming the level of grief claimed? Are the parties consistent? Do they come across as sympathetic? These are all the kinds of questions that you want to ask. And then, of course, as I mentioned, if there's witnesses that saw any aspect of the trauma, obviously it brings that more alive in the context, especially for a jury, I would argue. So that's really, something to be mindful of. And so just before we move on to some questions, the key takeaways obviously are that the Moore decision confirms the absence of a cap on FLA damages, but did suggest that $250,000 was on the high end range of those damages. You should be cognizant of particularly sympathetic fact scenarios as being worthy of these extremely high types of damages, and know that the Ontario Court of Appeal, even if you get a rogue, what you think is a rogue jury or judge, are highly unlikely to interfere with damage awards unless they shock the conscience of the court with particularly depressing or sympathetic set of facts. That's going to be a big challenge to overcome. So what you get is what you're likely going to end up with that. So we have a few more minutes here. If we want to just open up the floor for some questions, I'm going to turn it over to Ariana and she can check out what's sitting in the Q&A for us.
Well, thank you, Krista. We actually do have a few questions, which is great. So let me just pull up the first. Given that the court says there is no cap, how should we look at assessing damages for FLA fatality claims in light of the Moore decision?
I'll take a stab at this. I think, again, it really does come down to the particular set of facts. Some, like I said, have argued that this award in Moore wasn't enough and that, a jury could have very easily made a much higher award. And then, of course, others say, if we consider the cap, it's too high. So the big change is the fact that there's no cap. But I think you can still look to these high watermark decisions as being the yardstick, if you will. So Toe and Fiddler and Moore, And then, of course, the other cases that we were discussing will give some guidance as to the factors that a trier of fact is likely to look at. Like I said, especially for parents, the prospect of having more children or other children, or because it's really these cases you see where it was essentially the prodigal son who this family lost, and it was a bigger impact for them. So that's the kind of things that you really need to bear in mind. For assessing. I think if you've got something that crosses your desk with really tragic circumstances, that's when you might want to not take all the way to the end of a trial and see what you can do about trying to resolve a case like that. Obviously, if there's expectations that just don't align, then we need more decisions. But this signals to us that you should really take these kinds of cases very seriously, because they do have the potential to be quite high, as we've seen from more.
Great question. I think it actually ties really well into the next question in the chat. Did the Court of Appeal comment on the quantum of FLA damages themselves, or did they just defer to the jury?
So my read of the more cases, when they go through the facts, I think they don't necessarily comment directly on this is what I would have awarded, essentially. I think they say there's no question that the award that the jury made is high. The court says specifically, in light of the factual backdrop of the case, it doesn't constitute an amount that shocks the conscience of the court. Doesn't represent an amount that's so inordinately high so as to interfere with it. So, this case is strictly about the quantum determined by the jury, and that's how the court really handles it, and says, they look at the facts supporting the jury's award, and they say, okay, yeah, like we're looking at an only child, and just basically, I think what quote here was that the fire destroyed all hope of the society, comfort, and protection that Alicia would give to her parents. The parents never got to experience the rewards of, her. She was only 24 years old, so there was a lot of her life left. So they do point out a lot of those facts to support the jury's award, but they basically just leave it at, what, it's not as high as, it's not so inordinately high so as to touch that award. So that's really where they leave it. So I think that's an important part of their decision, is to say they're not necessarily going to delve into it too much, but they will look at the facts to make sure that they align.
Great. I see we do still have a few other questions, but I think we're running close to time.
I might be able to squeeze one more.
Squeeze one in. Okay. Great.
I just see, so is it correct to say that the award is more for the circumstances surrounding how the tragedy unfolds, rather than how much care, guidance, and companionship was lost in this case? I see there's a second part, but for that first part, Ariana, feel free to jump in with anything as well. But I would say, going back to what the court had reiterated, is the fact that obviously the circumstances themselves, the more tragic they are, I do think there's a bit of a correlation, but they certainly don't ignore the legal test for loss of care, guidance, and companionship. And what I just referenced from the case about, the impact on Alicia's parents, about not having her for the balance of what would otherwise have been a lengthy period of time, and expectation. So they do put a lot of weight into that. So I don't think that's something that would be ignored in future cases by any means. But naturally, if you think about yourself, if you were a juror member, maybe the more offensive the circumstances are, the more you want to help the family, right? And it's got to be people that you feel sympathetic for. So I think if you've got some really good plaintiffs that testify well, then that's where you're going to see higher awards for sure. And second part, so mental distress, it's not entirely new. There's a whole line of cases where the court has dealt with that. In fact, that alone you could do a separate webinar on. So I think that's something to consider for future webinar. But no, it's not new. It's just something that the court said it's beyond mere grief, essentially, was what they said in this case. So I do see we're already at 12:59. Time flies. We have so much more to talk about, but I want to make sure that we stick to our word about our 30-minute webinar. So if there are any other questions, in the Q&A, we'll take a look and happy to reach out directly to anyone. And if you have anything else you want to add, comments, questions, we'd love to hear from you. Shoot an email to Aria and I, and we can follow up from there. But otherwise, thank you so much for coming.
Thank you so much for coming, both to the webinar with these sensitive topics, but also for these really poignant questions. Before we let you go, I would like to highlight our next two upcoming webinars. The first is on October 27th from 12:30 to 1. It's called Don't Blame Me, a CGL refresher with a focus on the work product exclusion with Greg Brimblecombe. And the second is November 17th from 12:30 to 1, Vicarious Liability. It is all about possession with Lisa Code.
That's great. Okay, thanks everyone. And if you haven't signed up for our list, please do.
Thank you very much, everyone. Take care.
Have a great afternoon.